As the demand for arbitration continues to grow globally, the importance of ethics and sustainability has increased. Institutional integrity is central to the long-term success of arbitration. To maintain global trust and credibility, arbitral institutions must demonstrate their commitment and continue to lead by example, setting the standard for ethical conduct and sustainable practices in the arbitration process.
Sustainability is important in arbitration. We only have one world, and we have to do what we can to preserve it, and that includes arbitration. There are various initiatives out there. The Campaign for Greener Arbitration's one, and their Green Pledge that promotes the use of or careful thought in how we conduct our arbitrations. That involves thinking about whether we need to print all our documents or travel around the world or send witnesses halfway around the world just to be cross-examined. So I think it's important for us all to think about how we practice and in that way ensure that dispute resolution doesn't contribute to global warming and the other environmental impacts we're seeing on a day-by-day basis.
We strive to be sustainable and to have a low carbon footprint, and we continuously seek to improve the sustainability of our operations as well as those of our suppliers and partners. We're a signatory of the Green Pledge and a supporter of the Campaign for Greener Arbitrations, and we've implemented the Green Protocols. A recommended clause prepared by the Campaign for Greener Arbitrations intended to help the users of our services to reduce the carbon emissions and other environmental impacts associated with managing and resolving disputes is available on our website, and one of our senior counsels sits on the campaign's Institutions Task Force. As an organisation, we travel responsibly, and we've adopted to encourage the use of technology. We minimise printing and the use of paper, and we encourage recycling, and we promote sustainable practices. Our head office is a LEED certified green building, and we've adopted measures in our branch office to reduce our carbon footprint. We're also looking at ways in which we can work with our community and the businesses, governments and lawyers and arbitrators that use our services to promote awareness, provide education and launch new initiatives.
As a leading service provider in our field, we must also adhere to the same needs and priorities as our users. So against that background, we have taken a very clear stance over the last few years on topics such as inclusion, diversity and sustainability, and really incorporated these values into our operations. So for that purpose, we have, we are now signatories and supporters of various initiatives with those overarching goals.
One cautionary note though, in terms of electronic documents. I think that we all sort of assume that sending an email uses up very little electricity in its transmission and storage. But actually, it's estimated that every email sent uses about 4 grams, produces about 4 grams of carbon dioxide. So we need to think very carefully about how many emails we're generating in our arbitration proceedings. Do we need to send all those emails to copy to all of those people? And also how many documents we're including in our electronic document bundles? Can the tribunal even read all of these documents? Are they actually going to be referred to? Because our electronic document management is also important for reducing our emissions to make arbitration more sustainable.